the defense rests, let's lay it down. Gonna dig deep, wave that verdict round. The defense rests, time to analyze. With the evidence, we'll unveil the crime. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Gentlemen, last year, on April 20th, a young mother named Kristen Sigler threw a birthday party for her 3-year-old son, Stetson. Like many mothers, Kristen went all out for the party. She had a face painting station, a hot dog bar, entertainers, props and backdrops for photos, and even a bounce house outside of the party. Kristen has worked for several years at the Swan Boat Club in Berlin Township, Newport, state of Michigan, right on Lake Erie. She used the club's event space to hold the party. The party started at noon, and by a little before 3 p.m., the party guests had just finished singing happy birthday to the guest of honor. By all accounts, it was a very successful party. It was well attended, and the kids there were taking advantage of all the attractions. However, at the same time, less than 2 football fields away, at her home, the defendant was leaving, pulling out onto Branchaw Road. She was also headed to the boat club. Both of these events are memorialized on camera. The party was captured on the Swan Boat Club security cameras, and the defendant on a home camera mounted above her garage building across the street. Mariah Dodds, a longtime friend of Kristen's, and her 3 children, Jaden, Zayn, and Alanah Phillips, had just sat down at a table to enjoy their lunch from the party's hot dog bar. As they were beginning their meal, the defendant backed out of her driveway, accelerated her car in an arc out of her driveway, crashing into a small tree and then into her neighbor's full-size pickup truck, forcing it through a wooden fence. The defendant then places her car in drive and speeds off toward the boat club, just 4 houses down. As Mariah grabs cake pops at the dessert station for her kids, the defendant barrels at full speed down Branchaw Road and makes a right turn into the club parking lot. Ladies and gentlemen, my name is Ken Lorraine. I'm an assistant prosecutor for the County of Monroe. Along with my fellow assistant prosecutors, Christopher Marriott and Alexis Hatch, we will prove to you over the course of the next several days that defendant's actions in this case make her guilty of the charges of second-degree murder for Zayn and Alanah Phillips, OWI causing death for Zayn and Alanah Phillips, and OWI causing serious impairment of a body function for Zayn and Alanah's mom, Mariah, their brother, Jaden, and for Ed Smothers, Leah Stith, and Diane Medina. I don't particularly like long and winding opening statements. I like to give the jury what I would want if I were a juror. A roadmap, a table of contents to what the prosecution will present to you over the course of the trial. To simplify things for you folks, basically the way we're going to present this is you're going to hear from our witnesses in 4 groups. The first group will be guests and boat club members at the party. They'll talk about the party, they'll talk about the crash, and to some degree, they'll talk about what they saw of the defendant. Some of them will help us show you video of the crash and its aftermath. Some of them will simply tell you what they saw and what they remember, or what they don't remember, and they'll tell you what they went through. You will not hear from all of them. By most accounts, there were some 80 people in and out of the party through the course of the day, and several others that just wandered over from the boat club proper after the crash. The second group you will hear from is the first responders. The captain of the Frenchtown Fire Department and many members of the Monroe County Sheriff's Office. They arrived on scene shortly after the crash. They will give you more information about the crash, its results, and the steps they took to investigate it. Again, you won't hear from all of them. Law enforcement officers from at least 4 agencies were on scene, as were multiple fire departments, ambulance companies, and 2 life flight helicopters. You will hear the stories from the witnesses we call and see some of the footage from their body-worn cameras. Through that medium, you will also hear from the defendant. Next, we're going to call a group of witnesses that are necessary under the rules of evidence for you to hear about what was in the defendant's blood when she crashed her car. As I spoke about a little bit in voir dire, the rules of evidence are sometimes strict and not always straightforward, but they are important to ensure a fair trial both for the defendant and for the victims. Finally, you'll hear from some of the surviving victims. Mariah, Edward, Leah, and Diane will tell you what they can remember from the crash, about their injuries, and somewhat about their road to recovery. Before I conclude, I want to speak just briefly about the jury instructions that the judge highlighted and give you a sense of what the people think you should be watching for over the course of the next few days. We can bring up the... You don't have to be able to entirely read this. You'll get it printed out at the end of the trial. But just roughly, as to the 5 counts 4 through 9, of OWI causing serious impairment of a body function, we have to prove that the defendant voluntarily operated her vehicle, that she did so in a parking lot or a place accessible to the general public, and that while she was operating it, she was either legally intoxicated, which is what we all hear about when we think of drunk driving, that she was a .08 or higher, or that she was under the influence of alcohol. In other words, I could think of a 90-pound, 25-year-old woman who I could give 1 glass of wine to. She could be at a .04, but just be drunk out of her mind. So it's not always just a .08. That's the legal limit. And we consider if you're over a .08, regardless of how you feel, you're legally intoxicated. But it is possible for you to find intoxication under a .08. Or we can prove that she was impaired by the consumption of alcohol and the consumption of an intoxicating substance called gabapentin. And that in doing this, in driving, after ingesting these substances, she caused a serious injury to one of those 5 victims. Similarly, the 2 counts of operating while intoxicated causing death, the deaths of Zayn and Alanah Phillips. The beginning part of the jury instruction is the same. We have to prove the operation, its voluntariness, its location, and its intoxication. But in this, we also have to prove that due to the operation, she was the factual and proximate cause of the death of these 2 children. As to the people's first 2 counts, the counts at the top of the complaint, 2 counts of murder in the 2nd degree, the people will prove that the defendant's actions caused the death of Zayn and caused the death of Alanah, and that she had one of 3 states of mind. That is to say, what was her legal intent? We must show that she intended to kill, or she intended to cause great bodily harm. In other words, she drove through the boat club wall intending to kill someone, or intending to seriously harm someone. Or the 3rd state of mind, that she knowingly created a very high risk of death or great bodily harm by her actions, knowing that death or great bodily harm was the likely result of what she did. Intent is what is in a person's mind when they commit an act. It's what they are thinking when they act. The jury instruction will tell you that you determine someone's intent from what they said, what they did, and how they did it. It will also tell you that you can use any other facts or circumstances in the case to determine a defendant's intent. These are some of the things to look out for over the course of the next few days. At the conclusion of the trial, I'm going to stand back up here again, and we're going to go over a lot of the evidence. And the people will contend that on behalf of the victims and on behalf of the people of the state of Michigan, that you should find the defendant guilty of 2 counts of second-degree murder, 2 counts of OWI causing death, and 5 counts of OWI causing serious impairment of a body function. Thank you, folks.
Thank you, Mr. Lloyd. Would you like to make your own statement now or later?
Now, Your Honor.
Thank you.
There's no question this is very, very sad of what took place. Very sad. There's nothing nice or near nice of the events that took place, and 2 children died and people were injured. There's nothing. But what this case is about, bless you, what this case is about is, was there an intent to kill somebody? Was there an intent to be reckless? And I'll come back at closing argument, we call it, where we get to talk to you one more time. So we don't talk to you at all during the case, but then we're allowed by the judge to do closing arguments, and we try to put it together. Certainly, I can tell you by, we look at the police reports and things like that, and we had 1 or 2 hearings, so we know a little bit of ahead of time. It's like sort of, I mean to make light of it, but sort of a little bit like the coming attractions on a movie, whatever. So that's why we sometimes stand up here and we talk. It's not because we read minds. We have a good idea of the facts, at least how we interpret it. I, again, can't stress to you, and I'm very sincere, I can't stress to you how important this case is for everybody. It's for everybody. And for everybody to be able to move on. And I stand before you with a lot on my shoulders because I represent Marshella Chidester. She can't get up as a lawyer and do her case, okay? So I have a lot on my shoulders, and I welcome it. I can pick and choose at this age which case I want to do. And this, she needed somebody to come forward. And sometimes, and I have a lot of respect for news organizations, certainly, but sometimes it's just a snapshot or a conclusion, or maybe near World War II yellow journalism or whatever, or something to do whatever. But this trial, all of you sit back, attentive, all of you are back, and you'll be able to listen to all the testimony. What an honor to serve on a jury to begin with in America, but to this magnitude. You can really, you're serving on a jury. You are doing a job that probably, if it was another case, I wouldn't look forward to. Because you're going to make a decision during these trial of credibility, who to believe, who not to believe, what makes sense, what doesn't make sense, and that's what I want you to do. That's what we want you to do. So the proofs, we believe, are going to show this. And I don't have to make an opening argument. I can waive it completely or wait till the defense goes on. But I choose to stand right up because the plaintiff, the prosecutor, made a good opening argument. He made a good argument. The proofs, I believe, are going to show that you're going to get to know a little bit of Marshella Chidester through possibly people that are going to come in. That she was in the military at 18 years old. That she served 4 years. in the Army, the real Army. I'm not talking about something up north, and I don't knock that at all, but she was serving. She was serving. And you're going to get to know about her life through people, and that she's never been pulled over for a ticket in her life. She's a better driver than me. And she's never had a ticket to even get pulled over for in her 50-some years. We believe the proofs will show her credibility. And that's what this is. This case, like a lot of cases, are about credibility. And that she was an excellent driver. I believe the proofs will show, I know the proofs will show, that she suffered from seizures and neuropathy. And it wasn't something the proofs will show that is just made up that day. She had been going through it, the proofs will show, for a long time. A long time. And was treated at U of M, Cornwall, Beaumont, whatever name it goes by today, on 4th Street in Trenton. There'll be proofs on this. And it also showed that it didn't happen all the way that she had these seizures all the time. It'd be pretty rare. But when she had one, it was not good. I think the proofs will show that when she has a seizure, documented, her feet go down, like real hard, the proofs will show. And her hands too. And then after less than a minute, the proofs will show that it relaxes again and you're a little bit spaced out. And for up to an hour. The proofs will show on our side of the table that when you see the videos, and normally I'm not nuts about videos, but when you see the videos that they believe will fully support, it'll support a vehicle being put to the floor from her house to go 450 feet. Put to the floor. Metal to the pedal, pedal to metal, whatever. Put to the floor. The proofs will show such that going on is out of character completely. Out of character completely. Something happened. And we believe the proofs will show, you keep an open mind, please, will show that's exactly what the proofs will show, is that the feet go down. And you do, when I was growing up, it was called a hole spot. You punch it right to the floor. I never did that, but it was like drag racing back when I was growing up. And just took off in a gravel place. And the cameras catch this vehicle just taking off and going right there. The proofs will show. She won't drive that way. She's been driving a long time, 50, 55 years. The proofs will show that when this happened, and it's horrible, that the vehicle went in 25 feet into the building. Horrible as a birthday party. I've had children. I know. Couldn't imagine it. The proofs will show that when she was honest with them, because you look for other evidence for credibility, corroborating evidence, the proofs will show that she said, they say, what's going on? Police arrive. That I had one glass of wine. Well, police hear that, I'm sure, a lot. I've only had one or two, and they get arrested for drunk driving. So where were you? At Vernus. And the police immediately do their job, which is wonderful. Here's a defense attorney telling you, great, you did a great job. They went down there, they masked it off, whatever, taped it off, whatever. It's a criminal place. You were there at lunch. You paid by credit card, debit card, whatever. They get it with a subpoena. They talk to the lady first that works there, Kelly Thornton. I subpoenaed her to be here for the trial. And she says that, I know, Marshella and Don, her husband, and there was another couple that was here, but Don wasn't here. She had one glass of wine, and she had some soup and a sandwich or fish or something. They get the subpoena, she does a copy of it, and we'll have it as evidence. I'm not making it up. And it'll show she had 1 glass of wine. Exactly. So the proofs will show, I think, credibility-wise, exactly what she said before anybody went anywhere. She said, I had a glass of wine. And the lady that comes in, the proofs will show she didn't finish it. There was still some in it. And she packed it up, the food, and for her to take home. And she just lives not far at all from it. I'm very happy the police moved on it right away, because so many people sometimes say, oh, officer, I only had 1 or 2 drinks. The proofs will show it was less than 1. And the proofs will show that the officer asked her, well, what was her condition? It was fine. Okay. The proofs will show that she has this neuropathy, and when she walks, I'm going to have her walk in front of you. When she walks, the proofs will show she walks like this. Now, if I see somebody coming out of a porch or going to the car walking like this, I'm thinking somebody's, keep it clean, somebody's messed up. Okay? Somebody's been doing some drugs or alcohol. Unless you know the person from before. Never met him before, never met her before. She never gets pulled over, ever. So, here we go with a snap judgment. The proofs will show that this person's got to be drunk out of their mind. So, the proofs will show that the accident happened, of course. And the officers came up to her, the proofs will show. We expect the proofs to show. Then when they came up, they started talking to her. This was right after the accident. Somebody got her out of the car and she was sitting there. I think she got like an American scarf flag or something sitting there. She was a former Commodore. Never had any problems, ever. So the officers will talk and they'll bring in some video on that because we had a hearing. They showed some video on that. The proofs will show that they're talking to her. If anybody's been around with our life experiences, the proofs will show somebody's slurring, somebody's looks a little drunk, even a little bit. The proofs will show that she's speaking probably better than me, more clear than me. And that's up to you to see. I'm not making it up. The proofs will show that. Crystal clear. Now, she was just in a collision, had an attack, then went 25 feet into a building, and they're going to start interviewing her. The proofs will show that event, she talked about it's 1 glass of wine, truthful, and then they asked her, on a score of 1 to 10, the proofs will show, how intoxicated are you? Well, she's in another zone, going through a wall 25 miles an hour and having an attack. And then they ask her, well, are you able to drive? Well, hello. The proofs will show, am I able to drive? I just crashed into a building. So, the judge will, a lot of people say, don't leave your common sense out there when you're serving as a jury. You've got life experiences. Keep that with you. Don't let that out. Don't be sterile. You can bring life experiences in. You just can't make up your mind until all the proofs are in one way or another and deliberate and respect each other. The proofs will show that it's almost like an immediate conclusion on the police department, and I have great respect for the police. I have relatives, police. The proofs will show that they got a search warrant and wanted to get blood from her. She had no problem if you want to do a blow breathalyzer or whatever. They didn't ask her. We want to do blood. And she even signed a consent form. Didn't even need whatever. She's not hiding anything. There's nothing to hide. That they took the blood. They had it tested. We're going to get into all that. Not right now, of course, because I'm trying to somewhat keep it short. But there's a lot that's going to be covered because this didn't happen in a minute. It was a lot longer than a minute. And it's been a year. And this trial is going to be a few days long. So that's why I wanted to jump in and let you know at least where the defense is coming from, so you can have it in the back of your mind and say, you know, hopefully Mr. Clovis, Bill Clovis, let's see what he's talking about. Will this go together, like he says? I feel very confident. I'm not going to over feel confident, but I feel confident that the proofs will show what I just said, what I've represented to you. I'm pretty strong on my representations, or else I don't make it. The proofs will show that she always was cooperative. She was always crystal clear. The proofs will show that when they asked her to do a sobriety test of the alphabet, I'm talking about at the scene, she was able to do the alphabet. Perfect. No slurring. Perfect. Not skip anything, not say double, not miss it, not end early. That's another something to look at. Is that somebody, if you're going to say that they're so heavily intoxicated, and people don't know where they're at, what day it is, or what time. This person's saying the alphabet, talking like, almost like you and I. These are things I want you to keep in mind. Why am I hitting this so hard? And I'm sure the judge is looking at me right now, with all due respect, saying you're taking a long time. Because I got 2 counts of murder too on my client. That's why. It's called a capital offense. This isn't playing a little game. 2 counts of capital murder. Murder 2. And all the other offenses. That's why. And I've taken it very personal. Because I want to see what's done right. And I respect each and every one of you, especially when you're watching this. And it's a long time to be trapped in a seat that's most not comfortable. And we appreciate it. We thank you in advance. Please wait till all the evidence is in. They get to go first. I bite my lip, like I said earlier, till we get to put up any proofs. Please don't do a knee-jerk reaction and wait till all the proofs are in. Thank you very much.
Thank you, Mr. Clovis. First witness. Thank you, Judge.
People call Kristen Sagan.